Good day, colleagues, friends of the channel. Today, I wanted to just discuss with you a concept relating to examination in chief and how it is actually done, and what are important considerations when one deals with examination in chief. Now, at this stage, we are already inside the courtroom, and the trial is already proceeding. And there will definitely be different functionaries in a courtroom. And that would include, for example, your judge. It will include your prosecution counsel in a criminal case. And I'm giving this from a background of a criminal case. So have that context in behind you. And then there will be on the other side, the attorney on record would then be representing the accused person. Now, when it comes to examination in chief, there are certain important issues that one needs to keep in mind. One is we must always start in the beginning. Obviously, by this time, you've prepared your case, you've read the docket. If you are a prosecutor, you have actually gone beyond the consultation with your witnesses. And by this time, more or less, you have already determined what are the burning issues or issues that you would need to canvass in court. You more or less have an idea of the witnesses that you would need to call. You also have an idea of the witnesses you should not call. And you've gone essentially through the preparation phase. And now you are reaching that stage where you actually have to do the actual examination, and you lead your witnesses. As, let's say in this case, I will speak from a position as a prosecutor. Now, this is a place where you start now leading your witness, or you are a defense counsel and you have to lead your particular witness so that their story can come on record, and for the judge to be able to listen, or the court to be able to hear and be able to make a determination. And also part of the considerations as well is that one needs to actually know during this process what are the things that they would want to volunteer or should not volunteer, or explanation that is not necessarily warranted that one can give. But the main idea is to ensure that before you are done with your examination in chief, you must have ensured that all material aspects that the witness had to cover are covered. And so I want to start with this process so that you would be able to equally go back and do it yourself. So I'm going to deal with the pertinent issues, principles, tips, and general comments that I will go about doing this. And the book that I would also want to recommend for you for the same purpose is the Morris book, Techniques on Litigation, because I find it to be a very helpful book that guides you. But also there's a book of Willem Gravet that deals with effective trial advocacy, which you can also consult to help you to understand more or less how we should do this. Now, the first issue is determining now which witnesses to call. Now, remember, there are different issues at the end of the day that must be covered. And in order to cover these issues, you need a witness to come and cover that particular element. Now, every element that has to be proved requires somebody to testify on it. And this is a very important thing. So either you are in a position where you have to prove something, or whether you have to rebut something because it is required for purposes of the case. And then only after you decide now which witnesses to call on each point, because it's very important at this stage that you decide the issue on the one hand that you are dealing with, and then on the other, you must then decide which witness would best address this particular point or issue, or be able to effectively rebut this particular issue that we are dealing with. But equally, with the witnesses that we need to know the ones we have to call and why we have to call them and the points that they will need to cover. There are also witnesses that we need to determine that we do not need to call. These are witnesses we do not want, and then it's very important. There's no real negative inference that can be drawn if you as counsel decide not to call certain specific witnesses. So in my view, the court cannot reasonably make an inference that is negative, because sometimes you find that witness is not available at the time that you need because of some or other reason. But also when you look at the strength of your case or the weaknesses of your case, you realize, but no, this particular witness is not necessary for me to call. And this is a very important issue for me. But one of the most important issues that one needs to deal with, especially, is to prepare for the leading of your witnesses, because nothing must be just thumbs up, right? With everything, we need to prepare. And one of the important things is that we need to prepare thoroughly in order to be able to effectively conduct our examination in chief. Now, in order to prepare thoroughly, it's important because you have to understand your case to be able to present it, you understand? And in order to do that, you have to know all the relevant facts that pertain to the case. And once the facts are there, you need then to extract from those facts what is the essence of the case. You understand? Those are the things upon which the case will hinge upon. And then again, it's not just important to identify the essence or extract the essence. You must then realize this essence in court. And one of the other issues that's important after you've extracted the essence and now you are pushing to realize this essence is that you need to know the relevant law that apply to your particular case. Now, in order to do that, you need to clearly establish and understand what are the issues that you are dealing with and the evidence that you are going to present, and whether this evidence is admissible or it's not admissible. And that is very, very important. Now, we have to at some stage consult with each of the witnesses, because after consulting with each of the witnesses, one thing that is clear is that you will know what to expect from each of the witnesses. But also there will be times where issue regarding a location becomes important. And whenever a location becomes important in a particular case, for example, it's important for, let's say, for example, there's a particular building where the offense has occurred. In my view, it is equally important that before you start to deal with that issue, you must have visited that place. You must have visited that place, seen the outline of the place, so that when you later come and present about that particular area or building or location, it's a location that you are familiar with. Because it's not enough to see in the photographs, right? So it's good to do that. But also importantly, you have to decide very early on whether you're going to need visual aids. And if you're going to use visual aids, it's then important that you ensure that they are available on the day of the trial. And then that can be either photographs you want to use, diagrams you want to use, or whatever plans that you want to use. They have to be available. Again, remember, it's not just enough to have these large numbers of witnesses at your disposal. It's also very, very important that you know you must have a clear plan for each of them. You must know what are you going to lead this witness on, that witness on, because each of them have important aspects that you would have to lead them so that they can cover, right? Now, once you have a clear plan of what you want from which witness, then And the witnesses you're going to call, simply draw a list of those witnesses, the topics that each witness will have to cover, and then if you're going to have a bundle of file or things, have them clearly paginated so that you know you don't waste the court's time by trying to work through maybe a bunch of documents. So you have a clear reference of these things. It's for me very, very important. Easily accessible, paginated, and you know where in the bundle that each of the witnesses is going to be at. All right. Now let's then go back now, because we have now the clear background of what we need before we can get even to before we get to a stage where we have to start with the leading of with the leading of witnesses. All right. And so we have clear considerations, the issues that we have to be clear about, the law that applies have to be clear about, the essence of the case we have to be clear about, type of witnesses we want to call, type of witnesses we don't want to call, and more or less the plan that we have with all of those witnesses. Now that background is necessary because only when you have it can you then meaningfully start to deal with the issue of examination in chief. Now, what is the first important rule in dealing with examination in chief? Because this is highly, highly important. I cannot overemphasize this general rule. And it's a very simple rule that you are not allowed, one, to ask leading questions. You are not allowed to ask leading questions. And I will get later on as to why and all of those things. Now, what is the purpose of examination in chief? The purpose is simply to ensure that you start to prove all the elements of your case, because that is what we want. You are going to call these witnesses, they are your own witnesses, and you want to prove certain elements using them. Now, the obstacle that you have as counsel is then this problem of you are not allowed to put leading questions to your witnesses, because in simple words, if you put a leading question, you are simply testifying yourself as counsel, because you suggest the answer or you assume a fact that has not already been canvassed in court or has not been established in court, and that is equally problematic. And one of the things that we're going to deal with shortly is how then do I go about phrasing questions in such a way that they are not leading questions. And this is very important. Now, I've already told you what is a question that is leading. It is a question that suggests the answer. It is a question that assumes a fact not yet established, right? Now, a non-leading question is just the opposite. You see, it does not suggest the answer. It does not assume a fact that is not yet established, right? Now, there are simple methods that counsel can use to be able to do this effectively. Now, immediately when a question starts with, for example, do, did, is, was, and where, it is automatically a leading question. Is the color green? Already when you say, is the color green, you are suggesting the color. The color is the answer. You understand? Or you force a person to get into a place where they have to say yes or no. And that is not the essence of a leading question. But you'll get to a place later on where we deal with introductory issues or issues that are not so controversial, where as counsel you are allowed then to ask leading questions or yes or no questions, and that is not also a problem. But immediately as counsel, your ear must be very open. When you get a question that has the following, do you, 1, 2, 3, 4, or did you, 1, 2, 3, 4, or is, was, where, it already suggests an answer. And immediately, at the end of that question being phrased, you can object to say, but judge, this is the counsel is either testifying or leading the witness. Now, what are examples of a non-leading question? These are questions that, remember, they do not suggest an answer. They do not assume a fact that's not yet established. Questions like what happened? Like simple, what happened? When did it happen? How did it happen? Why did it happen? They are questions that do not in any way suggest an answer, and they require the witness to provide an answer. You understand that those are the questions that you want to ask. So what? Question. When? Question. How? Question. Where? Question. And why? Why did this happen? What was the color? When did you arrive at the bar? How did you get to the bar? You understand? So all those questions do not in any way suggest an answer. So think of the answer you want. And this is very important. Think, before you ask a question, think of the outcome, the end result that you want from the witness. And having the outcome, then you start to quickly phrase the question so that you can extract that which you want at the end of the day. A simple technique that many people, or methods that people use, is a piggyback. And often you start in a chronological order. For example, on such and such a day, where were you? What time did you arrive there? With whom were you with at that place, at that time? What did you do? What did you do after? After that, what happened? What did you discuss? Did you discuss 1, 2, 3? Or something like that. But you basically use the previous question and you simply continue thereafter with a preceding question. And this follows more or less a logical, sequential step. And there's nothing wrong with it. Now, what are the keys to good evidence in chief? Because these are important issues that you must have in mind as counsel, and because they will help you. Now, the first thing that is important is that you must have a clear plan. And the plan must consist of, what is it that you must know what you want from the witness. You must first know what you want from a witness, why you want this information from out of this witness, and have an idea of how you propose to get this information out of the witness. Because if you don't know what you want and you don't know why you want it, it is already a problem. But even if you know what you want, you know why you want it, but you don't know how to get it out of the witness, that is also equally a problem. Now, where do we start? One, start by you obviously, when you call your client or your witness to come and testify, he comes to join a conversation, right? A conversation is happening between, in my view, between the judge, the counsel, and the other counsel. Let's say in this case, we have the judge, the prosecutor, and the defense. So there is this formal conversation that is taking place. Now you bring a fourth party to come and join this discussion or conversation. Now, it is obviously very courteous that as somebody new joins a conversation, that you introduce that specific somebody and how they fit into the conversation. That is a very clear thing that you must do. So the first thing is you must come and introduce the witness. Secondly, you must deal with the background issues, because that provides the context. Or these are often common cause issues that there won't be fights about, but in my view are very, very critical. But also, as you are doing these introductory issues or background issues, there it is not a problem. You can ask a leading question. You can ask leading questions. But when we start to get to the core issues why we are here, controversial issues, then you stay clear from leading questions, isn't it? Think of it as now the person is going to tell his story. You've introduced the person, you've set the scene by dealing with the background issues. Now you want them to tell a story. Think about it as if you're going to paint a picture. You want to paint a picture for the judge so that the judge can understand what the issues are or what happened in a particular issue. And what is clear is that you, as for example, the prosecutor, you are the painter. Or if you are the defense counsel and you are the one that is your witness, you are the painter, right? You are the painter, but the brush that you use, the paint that you use, is the questions that you put to the witness, and then the witness himself is the one that is doing that you use as a stroke, right? So they are the ones that are painting this picture. Now, you've already introduced the witness, so you painted the witness, you painted the background. Now we go to the controversial issues, and the more you get closer with your paint to those controversial issues, the clearer you need to paint, so that people that are looking at the painting can clearly understand far more greater detail what is actually going on. So on the introductory and the background, you could ask quick questions just to get by then. Because the context, introduction is important, background is important, but the real issue that we are here for are the controversial issues. Now, it's important that all people generally, they think logically and they think chronologically. So you start from point A, you move to B, you move to C, or you start from 7 o'clock in the morning, 7:30, 8 o'clock, you move in a clear chronological or logical order. The other method you can explore instead of the others is then you deal with different topics. You see, depending on the type of case you have, deal with topic 1, then move to topic 2. But be very clear as you engage the witness to say, first I'm going to deal with this particular topic. Then you deal with the topic. Then you say, now I have concluded, we are concluding on this topic. I'm moving to this topic, because it's very important. It makes it easier for the judge to follow. It makes it easier for witnesses to follow, because one of the worst things that you would want is to confuse the judge, who must give a finding and a sentence, or you confuse. If you confuse your counterpart, that is fair. It is fair in my view. Let them be embarrassed there, but you don't want the judge to be confused about what we are dealing with. Now, the rule of thumb is that you must be very, very, very prepared, because if you don't prepare, you prepare to fail. And this is very important. So you prepare very well, you extract the essence of the case from the facts, and it's important that you know all the important facts. You can't just know some facts, especially the crucial ones, where they're very important. Even the unimportant facts, you must know them. Now, remember now, there are different tempos that you would follow. And you will spend very little time, like I said, on the introductory issues, on the background issues, and you'll deal with them very quickly. But when you get to the actual core issues, you will reduce your speed and you will move like a tortoise, because you want them to be clear, you want them to be crystal clear, And if you rush through, there might be issues that you miss. So take your time on the more important issues, controversial issues, so that there is clear clarity and so that everybody can follow. And that's important. And it's important also, as I've alluded to earlier, that when you move from one point to the next, be clear. Tell your witness that now I'm moving from this point and I'm going to this point. Like I've said, we are holding a very formal conversation between counsels and the for the audience of one, which is the judge. So it's a private conversation. It's very formal conversation with the counsels, with the witnesses also there, and then it happens with the public also there. Now, there are certain instances where issues happen quickly, like your accidents, for example. And when they happen quickly, you must understand that these things happen in seconds and milliseconds, and the time to clearly observe, to gather your thoughts and understand how things unfolded can be very problematic. So do not try to get your client to commit, for example, to things like time. How long did it take, as if they had a watch there examining exactly how everything happened? Or to try and say, to determine the distance between this car and that car in those moments, because those cannot be clearly established properly. Just that is a problem. Now, let me just go to making general comments in terms of leading of leading questions. One, we've got various characters, like I've already alluded to. We've got counsels there, we've got witnesses there, and you will have the judge, because that is the exchange. The counsel is talking, the witness is talking, but now and then the judge will come in and chip in. So the evidence of this witness are very important because it is their story that is being told and that needs to be understood, right? So that you have the lead, who is maybe, for example, the complainant would be the lead witness. Then you have people that support, right? So you have the main witness, then you have all these other witnesses that are supporting. So that is a very important issue. Now, let's get to the witness. You know, sometimes we understand that the courtroom can be a very intimidating place, right? It's intimidating not just for counsels, even magistrates themselves or judges themselves, but it is equally or more intimidating for witnesses. So you have to ensure that you remind witnesses that a courtroom is not there, or the counsels and judges are not there to be funny, and they must speak with confidence, and they must be they must speak in such a way that they inspire confidence, right? And because only when they are confident can we really rely on what they are saying. But if people are not confident, if people sound questionable, then that can undermine the case. And part of the issues is when you are a counsel and you are dealing with a witness, understand that they are equally intimidated, many of which don't even want to be part of the process, right? They regret even having to write statements. And so be very courteous with them, be very respectful when you are dealing with witnesses, even if it is your opponents, even if it's in cross-examination. You must be very courteous and respectful, because that is one of the things that inspires confidence, or that makes people cooperate effectively. And it must be clear from where you are starting with the witness, and the direction that you are taking must be very clear so that they can be able to follow. And ensure that they also speak clearly. And because if you are the counsel and you are not posing clear questions, chances are you'll get the wrong answer, or you will get a response that is equally not so clear. And if you're going to be very ambiguous or confusing, then the response will follow the same. Understand that there are various people that must consider the question together with the response. I've already spoken about the counsel for the opponent, the judge, yourself, the judge, and your opponent are all considering these questions. But there are certain implications that arises as a result of misunderstanding that can be very detrimental, especially if it is the judge that has a misunderstanding. Because if the judge has a misunderstanding, it can damage your case and it can embarrass you in the process. So it damages your case because the judge will not find in your favor, and it embarrasses you as counsel. Your opponent, it can damage their case and it can embarrass them if they don't understand. And that is why it's important that we all be clear. And if it is your witness that has a misunderstanding, it can also be very problematic because it will ruin your case, embarrass the witness, and an embarrassed witness can equally be a serious disaster, guys. It can be a very serious disaster if you have a witness that's ashamed, that cannot speak, that is just confused, that is not able to articulate their points or bring their points across. So you must always, as counsel, try to be as precise as possible when you engage in things, and never, in other words, never ask a question that you don't know the answer. And this is a very important mistake that many counsels do. Never ask a question which answer you do not know. So when you start, you must remember that it's like a running exercise. Before you start to compete in a race, you need to start to warm up the body. You need to start to warm up the body. And only when the body is adjusted can you get into the mood. The same with the case. The witness is uncomfortable in the beginning. Ask simple questions so that they can settle, relax. And then as you see them relaxed and being comfortable and realizing that this is not such a big thing after all, then you start to hit with the more serious issues. So preliminary questions, introductory question, background issues, but don't waste the court's time with introductory issues and background issues. Remember when we dealt with the tempo, the speed that you must deal with at various stages. But you as counsel must definitely be very calm, very confident